Right. Well, hello, everyone, and welcome. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pittman Legal, and thank you very much for joining us here today for our webinar on misleading and deceptive conduct. Before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. If you haven't joined us for one of our webinars before, or if you have, a very warm welcome again. We run these webinars regularly on various legal topics, as we hope they'll continue to be a helpful resource to share with you some must-know information and guidance on different topics that might be of interest and things that we're seeing in our day-to-day practice as sort of red button issues. And you can catch up with the recordings and slides for this webinar and previous webinars by heading to our website and clicking on the resources section. Now, before we begin, we are lawyers after all, so we do need to put up some fine print. Needless to say, we can only give you some general guidance in this session today. Everybody's situation and business and things that you're doing in your businesses is a bit different. So that's really important to keep in mind. So please keep that in mind as we go through the content. And if before doing anything, please get in touch. If we raise anything that's of specific concern to you, get in touch. We'll have our contact details up on the slides at the end. You can also find us through our website. And also keep in mind that the content today is based on the law as it stands here in Victoria, although a lot of what we'll be talking about is applicable federally as well, if you are joining us from interstate. So today we'll be looking at the topic of misleading and deceptive conduct, and this is actually quite a wide area of law. So in today's webinar, we'll be focusing on a few key areas where engaging in misleading and deceptive conduct can have some really potentially serious consequences, including the three main areas we'll be looking at in contracts, the Australian consumer law and property. It's also an area that swings a lot on particular circumstances, and there can be a danger in a one-size-fits-all approach. So what we're aiming to do today is give you some handles on some key things you need to know, so you can take that back into your businesses and use that to identify any areas that you think might need looking at. So I'll shortly hand over to Caroline Caligari, who will start taking us through today's content with Vash Naidu. Caroline's a special counsel in the Disputes and Litigation team here at Sharrock Pittman Legal, and she has many years of experience in this area. I know she and Vash are both looking forward to sharing their knowledge with you today. Just a couple of housekeeping items before I hand over to Caroline. We are in webinar mode, so your cameras are not on, you'll be relieved to know, and we are recording the session. It will be available later on. If you do have any questions, please feel free to type those into the Q&A box as we go through the session. We'll try to get to questions as we go along, and we'll also have some time for questions at the end. We are conscious of time, however, so if we don't get to all of your questions, don't worry, we will get back to you afterwards. And we'll, as I said before, we'll also share our contact details at the end. So if you're more comfortable getting in touch directly with us about your questions, please do feel free to do that. So without further ado, I'll hand over to Caroline. Thank you, Caroline.
Hello, everybody, and welcome to our session today. We're going to do this as a kind of more practical guide to misleading and deceptive conduct because, as Mitch did say, this is quite a wide area of law. It's quite complex. There's lots of different legal tests that are applied depending on the circumstances of the conduct itself. So this is meant to be just a bit of a guide to the law in general and to give you some practical examples and things to watch out for and be mindful. So we're going to start with what is misleading and deceptive conduct, both from a subjective and objective perspective. Why is it important to know about it in your business practices? What are the consequences? How can you avoid it? And then some recent cases and time for Q&A. So without further ado, let's get into the meat of this presentation. Now, what is the dictionary definition of misleading and deceptive conduct? Misleading is giving the wrong idea or impression. And deceptive means giving an appearance or impression different from the true one. As you can see from these two, the idea is that the idea behind misleading and deceptive is that you're giving somebody the wrong idea, really, in relation to a matter. which then takes us to the legal test. You can just flip the slide, please. There's a wide body of law and different tests depending on whether the statement is as to a current or a future state of affairs. But at its crux, in general, conduct is misleading or deceptive where objectively, and that's an important part of the test here, it actually induces error, is contrary to fact, or has a real tendency to lead someone into error, which goes back to the impression that what you're saying is giving somebody. Now, when we talk about it being an objective test, what the court is looking at is not what you intended by what you were saying or what your conduct was meant to convey to somebody, but actually what your conduct would convey to an ordinary and a reasonable person. That is the test as to in determining whether the conduct has the capacity to lead someone into error. So, next slide, please, Mitch. It doesn't matter whether you meant to lead someone into error, whether it was a mistake. All that really matters is whether whether it would, to an objective person, give rise to misleading and deceptive conduct. However, if you are deliberately hiding something or you're intending to mislead or deceive somebody, then of course that's going to be a factor that weighs towards a finding that you have engaged in misleading or deceptive conduct. It's a bit like that gut feeling. If your gut feeling is, oh, maybe I should hide this, then I think you should carefully think about it. Now, conduct in this context includes both actions and inaction, words that you actually say, and silence. When it comes to silence, you can mislead somebody by omission. That is so especially in circumstances where you're deliberately silent in the face of a direct question, or you know that the other side has made a wrong assumption based on what you've told them, and you don't take steps to correct that. Now, generally, only statements of fact or law can be misleading, not statements of opinion, unless the statement of opinion you've made is made fraudulently and with no basis whatsoever. But we're not really going to dig into that part of the law when we're looking at it today. Next slide. Now, why is it important for you to know about misleading and deceptive conduct? Well, the answer is sort of a simple one, because it can impact on you in your day-to-day dealings with other businesses, customers, etc. One of the main areas where you see misleading and deceptive conduct being litigated is in the area of contract law, particularly in relation to your negotiations for a contract. Now, we all know negotiations for a contract can have important legal consequences, both for you and your business, but they especially can have bad consequences if you've entered into a contract with somebody and that party has done so in reliance on a false belief that was induced by statements made by the other party or by their conduct. If that happens, then that can give rise to the contract being voided and the misled party having a right to damages, where the damages arise as a direct consequence of the misleading or deceptive conduct. You see this sometimes too in the contractual space where it comes to settling a matter. So if you've settled a matter based on something misleading and deceptive, that can give rise to the whole settlement of a matter coming undone. Now, there's differences between commercial contracts and your kind of private contracts. Commercial contracts, a business is generally engaging in conduct in trade or commerce during their contract negotiations, which means they're going to be caught by Section 18 of the Australian Consumer Law, which is federal law, as well as its state-based legislation, which incorporates the Australian Consumer Law. Section 18 provides that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. Getting tongue-tied here. A person can be the corporation or the business itself, or it can also be the individual making the representation. Section 18 applies to many business-to-business transactions, as well as to business-to-consumer transactions. So it can capture you in most of your dealings. The individual who was involved in the contravention, for example, a director of a company, can also be personally liable for damages, as well as the corporation itself. Next slide. Now, there's Section 18 of the ACL, which captures commercial conduct, but what about a private contract? Well, engaging in misleading and deceptive conduct in a private contract negotiation, so not in the business context, I might be selling my car privately to somebody, can still give rise to liability as a breach of the law and may give rights to the same rights that we were talking about to void the contract or to damages under the common law of misrepresentation, which is a contractual cause of action. Now, a misrepresentation arises where a false statement is made, either deliberately or unintentionally, to induce someone to do something they would otherwise not have done. So again, we go back to where somebody's making a statement which might induce somebody into error. Now for the practical examples. We put our heads together to come up with some examples in this area that might get you into trouble during contract negotiations. It includes things such as, and of course, we know the test is objective, but if you are deliberately withholding important information from somebody, then you can be sure you're probably ticking the box of engaging in misleading and deceptive conduct. If you make a statement that fails to disclose important information, if you give a false impression about something to do with the business, if you provide incorrect information during the due diligence phase, I think Vash is going to focus on a case example in that area for you later on. Not correcting the other party when you know they've made a false assumption based on something that you've told them, or making a statement about a future state of affairs where you have no reasonable basis for making that statement. So, moving on from contract law. Another area where misleading and deceptive conduct we're seeing more and more of it coming up in actually, is in the case of property law. Now, that's not unusual because, you're entering into contracts and negotiating contracts in the area of property law. But it's also important in the context of a property transaction because it can give rise to breaches of the Sale of Land Act. Particularly now that they've changed the material fact disclosure sections of the Act. So liability can arise under both Section 12, which is the material facts section of the Act, and it's where you make a false representation, or under Section 32, where you fail to disclose matters that are required to be disclosed. Now, Section 12 has not been the subject of much case law to date, but it is an up-and-coming area of potential litigation, and we've gotten a few inquiries in this area. Now, a breach of Section 12 itself is actually a penalty provision. So it's not one that you can necessarily yourself sue for, but conduct in breach of Section 12 could give rise to a claim for contractual misleading and deceptive conduct, or under the ACL if it was in trade or commerce, such as a big property deal. Now, Section 12 provides that a person who, with the intention of inducing any person to buy land, knowingly or recklessly makes or publishes any false representation or willfully false promise. And here you can see where that part of the test is very similar to the test for misleading and deceptive conduct. We're going to skip through the next few parts of the test because I gave you the whole section because it's important that you see the whole section. But the other important part of the test, if you could just flip the slide, please, Mitch, is where you state or publish any statement that some other person will at some future time obtain something in relation to the land. Again, that's a future representation in relation to the matter. Or, and this is the material facts disclosure section, subsection D, where you make or publish any statement, promise, or forecast which you know to be misleading or deceptive, or you knowingly conceal any material facts or recklessly make any statement or forecast which is misleading or deceptive. And it's quite wide there. And that's where the test for misleading and deceptive in the ACL and the cases surrounding that will really come into effect if somebody is going to litigate a case in this area. And then as you see, it's a penalty provision. So you're guilty of an offence against the Act, and there's a penalty of 120 penalty units or imprisonment of a term of not more than 12 months. Now, usually you're not going to go to jail, but a fine of 120 penalty units, where a penalty unit is around $120, is quite a bit of money. Moving on. Now, examples of conduct that could get you into trouble in this context. First one is failing to answer any questions about the structural soundness or quality of the property honestly and completely. Not disclosing something material to a purchaser that might impact their intended use of the land, particularly in circumstances where you know what their intended use is going to be. For example, not disclosing that hazardous material has previously been used on the site, or you have knowledge of an upcoming development nearby that is going to impact the use. Withholding reports that you've obtained about the property. For example, a report which discloses a risk of termite infestation, and which you could see might be material to somebody in their decision to purchase the property or how much they're going to offer to purchase the property for. In the more private context, but it also applies in the commercial context, not disclosing building work or other work done without a required building permit, planning permit, or that is otherwise illegal, or leading someone to believe that it was done with the required permit when you know it was not. And another thing, material fact disclosure, is being on notice of a future development near the site but not giving any disclosure. And that's probably important, especially in the commercial context where you're also selling it as a development site. Next slide, please, Mitch. Any questions so far, Mitch? Okay, so we'll keep going. The last area that we wanted to touch on was in relation to the consumer law. Again, the main section is section 18 of the ACL, as we referred to previously. It replaced section 52 of the old Trade Practices Act, and is the law in relation to that area is applicable. Now, a business needs to be careful not to mislead and deceive, not only in the contractual context we talked about, but also when it comes to its marketing and its advertising. And we picked this off the ACCC website. There are two fundamental rules of advertising and selling that you need to be aware of. You must not engage in conduct that is likely to mislead or deceive, and you must not make false or misleading claims or statements about the products or services. Now, in practice, there's overlap between the two rules, and a particular statement could breach both. And there are other sections that we haven't gone into other than section 18 of the ACL, which are specific to making false claims in your advertisements.
I'll just jump in, Caroline, and just referencing the Trade Practices Act. I just thought I'd throw in that in my area of practice in commercial law, I still see trading terms and conditions and contracts from businesses that refer to the Trade Practices Act from the 1970s, even though it was replaced with the consumer law a number of years ago now. So just a bit of a tip for everyone: if you haven't looked at your contracts and terms and conditions for a while, if you have a look and there is reference to the Trade Practices Act, it might be a bit of a prompter just to look at getting those updated. Likewise, if you're on the receiving end of a contract from another party, it could be a bit out of date. So if you've got any questions on that, do get in touch. Thanks, Caroline.
Thanks, Mitch. Now, when it comes to your kind of advertising and whether something's misleading, deceptive conduct, puffery is not core. Now, puffery is a term used to describe wildly exaggerated, fanciful or vague claims about a good or service that no one could possibly treat seriously or find as misleading. For example, a statement that you sell the best food in the entire universe, or that you have the yummiest food that ever existed in the whole entire world, because you can see that's wildly exaggerated. And so you wouldn't be caught for misleading and deceptive conduct, but there is a fine line. So be careful about the claims that you make. Another area which also has to do with your kind of advertising and marketing of your business, where you can breach the consumer law, is in the area of intellectual property, particularly where you are using a trademark that is deceptively similar to another trademark. Now, you'd be breaching the trademark itself and the Trademarks Act, but you could also be engaging in misleading and deceptive conduct by holding out to the public that you might actually be that other company, or that because your name is so similar that you have some association with it. And this in turn can cause damage to either the consumer who deals with you, thinking that you're the other business, or the other business which loses commercial opportunities to you. And, I've seen this happen in my practice before, where, for example, there's been a new product kind of out on the market. There's been lots of advertising about it on the radio. And then another company goes, oh, that sounds similar. I'll name my company similar to it. And then people Google on the website because they've just fleetingly heard the name on the radio, and they are misled onto the other website because our memories of what we hear are quite fleeting. And that could give rise to misleading or deceptive conduct. So other examples of conduct that could get you into trouble in this context, so in the advertising space and the intellectual property space, is representing a product or service does something that it does not do, advertising a product or service that you don't supply to get people in the door to buy an alternative product, failing to tell a consumer that the product they are buying is incompatible with other products they own when they are looking for a compatible product. So if somebody goes in and goes, I have, an Apple iPhone and I want to be able to have headphones that are compatible with the Apple iPhone, and you sell them one that is not compatible because you want them to go buy a different phone or a different product. Probably a bad example because it's Apple, but it's the one that popped into my head. As I said before, deliberately naming a business really similar to another business to try and lure their customers to you. Representing you have an association with a major brand when you do not. Making your website look like another company's website to lure customers to your site, for example, by using really similar color schemes, fonts, and copying the kind of look and feel of their website. Not disclosing key conditions on your offers where that key condition might impact on whether somebody's going to come to you. And making a health-related or other scientific claim about your product with no scientific backing whatsoever. Mitch, I see you're ready to step in there.
I was just about to say, also be on the lookout for your competitors doing these things. We're often approached by our clients who discover that their competitor is maybe their website is very similar, or they're doing things that could be treading over this line. So if you do find that's the case, get in touch and we can give you some advice on that front as well. We unfortunately do see some very blatant examples of that kind of stuff, and there's obviously various things we can look at doing. So just as Caroline's pointing out things to avoid doing, do keep on the lookout for others who might be doing it and how that might be impacting on your business too. Thanks, Caroline.
Thanks, Mitch. That's a really good point. So those were all the examples of the conduct and the things to look out for. But what are the consequences of you engaging misleading and deceptive conduct? Or I guess one of your competitors as well engaging in against you? Well, consequences include liability to compensate the party harmed by your conduct for the damages they suffer as a consequence. And you can imagine specifically in kind of big contract negotiations, there can be some big money involved in such claims and some big losses that are suffered. The potential ability to rescind or void the contract, and because we're not making this legalistic today, we're not going into the details, but the availability of this really depends on the circumstances of the case. The possibility of an injunction to stop your conduct, that will arise a lot, especially in the intellectual property kind of space. Civil penalties and other undertakings being imposed by the ACCC if the conduct has a wider impact on all consumers. And of course, you cannot discount the monetary consequences, the non-monetary consequences, such as damage to your personal and or business reputation, which can have far longer consequences than just having to pay out money to somebody for the damages. The other thing and why it's important is that liability can, in the right circumstances, be personal as well as corporate liability. This is especially so in the context where directors might be held personally liable for statements that are made where the corporate entity itself is no longer trading or has become insolvent. So the party can't go after the corporate entity, they might go after the directors, particularly if the directors have money behind them. Some practical tips. How do you avoid misleading and deceptive conduct? Well, don't say anything you don't have a reasonable basis for saying or you can't back up. Document everything. When you are providing somebody with information, it must be provided fully. In contract negotiations, if something is likely to be material to you, it's likely to be material to the other party. So your gut should probably be, don't withhold it. If you are asked a direct question, answer it. Don't keep silent. And of course, this is the lawyer's one that we always say. If you're in doubt about disclosure, speak to your lawyer about whether or not you need to disclose and get specific legal advice. It's better to know rather than to stay silent and risk a claim against you later on. I think that's it for me, Mitch, isn't it? It is. So we're going to do a bit of a chair shuffle here. I'm going to pass you on to Vash now, who's going to speak about some recent case examples and give you a little bit more of a feel for the background facts, which might give rise to a misleading and deceptive conduct claim.
Hi, everybody. Okay, so now just having a look at the first case example that we have here is Telstra Corporation Limited against Singtel Optus Proprietary Limited. This case was heard in the Federal Court of Australia in 2020, in which Telstra was the applicant who brought an action against the respondent Optus for misleading and deceptive conduct in relation to a series of advertisements. Now, by way of background, in this proceeding, the applicant, being Telstra, claimed that by a series of advertisements that stated covering more of Australia/state than ever before, the respondent, being Optus, through television, in print, online, and by digital billboards, engaged in misleading and deceptive conduct in contravention of subsections 18.29(1)(b), 29(1)(g), and section 34 of the Australian Consumer Law. Now, just highlighting again what these sections at a very high level provide, it's that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive, or make a false or misleading representation that services are of a particular standard, quality, value, performance characteristic, use, or benefit. A few features of the advertisements included images from rural, regional, and urban Australia. It had Optus's yellow yes logo superimposed over each of the images, basically identifying Optus's brand. And in the television advertisement, the statement covering more of Australia/state than ever before appears after the images, followed by the word Optus. Now, Telstra argued that the advertisement conveyed to the Australian public representations to the effect that Optus's network or networks covered more of Australia or the relevant states than any other network, including Telstra's. So at a high level, Telstra submitted arguments that stated the representations conveyed were plainly open and not extreme or fanciful. The broad class of consumers could not be expected to pay close attention to the contents of the advertisements, and certainly not the attention focused on viewing and listening to the advertisements by the judges obliged to scrutinize them in legal proceedings. Telstra also submitted that the court must have considered whether a not insignificant, or in other words, the significant number test of ordinary or reasonable consumers would be likely to be misled or deceived. Now, in defense to the claims, at a high level, some of the arguments raised by Optus were that no such representations were conveyed by the advertisements, referring to another federal court decision that highlighted that the central question is whether the impugned conduct, when viewed as a whole, has a sufficient tendency to lead a person exposed to the conduct into error. Now, this really focuses on the contextual approach to assessing the representations made rather than assessing the representations in isolation. Optus further submitted that there were no comparisons made between Optus's network and networks of any other telecommunications provider, and that all that was conveyed by the advertisements were that Optus's mobile network had more geographic coverage across Australia than Optus had ever had before. Finally, Optus argued that based on previous case law handed down by the High Court of Australia, the correct test to be applied when determining whether conduct was likely to mislead or deceive was to consider the reaction of the ordinary or reasonable member of a class that the representations were directed to, rather than the reaction of an individual or class that may be deemed to be extreme or fanciful. Now, the outcome of this case, the judge agreed with Optus, stating that the ordinary and reasonable members of the broad class to whom the advertisements were directed to would not be likely to be misled or deceived, and outlined that the test established by the High Court of Australia in previous cases were clear and should be applied. The judge stated that the number of different scenes resolving from rural to urban, each superimposed with Optus's Yes logo, clearly conveyed the message that Optus's networks were available in each of those locations. And the reference to covering more of Australia/state than ever before, followed by the word Optus, merely confirmed what was already apparent, that being the advertisements concerned Optus's mobile network, which is the only context in which the concept of more coverage made sense. Furthermore, the judge stated that the advertisements contained no reference to any other provider other than Optus, so no comparison could be made, and that the focus was on Optus from the beginning to the end of the advertisements. So ultimately, based on the contextual approach, by the time the final image and the alleged offending words were reached by the viewer, they knew the advertisement was about the areas where Optus's mobile networks were available. Ultimately, the application was dismissed and Telstra were ordered to pay Optus's costs as agreed or taxed. Next slide, thanks, Mitch. So just based on this, a few questions for you or your lawyer to consider based on this case and whether conduct is considered to be misleading and deceptive are: what is the actual behavior alleged to constitute this misleading or deceptive conduct? What is the actual misrepresentation alleged to have been conveyed, or what error were consumers allegedly led into by the conduct? How would a court evaluate the relevant class of consumers alleged to have been misled? Or how would a court reach the conclusion that the conduct either was or was not misleading or deceptive? Next slide, thanks, Mitch. Now, before we move on to the next case example, I will quickly note that this case referred to a decision of the full court of the Federal Court of Australia in ACCC and TPG Internet, which highlighted a few key principles in relation to misleading and deceptive conduct. Firstly, conduct is likely to mislead or deceive if there is a real or not remote chance or possibility of it doing so. Secondly, it is not necessary to prove an intention to mislead or deceive. Third, it is not necessary to prove that the conduct in question actually deceived or misled anyone. Evidence that a person has in fact formed an erroneous conclusion is admissible and may be persuasive, but it is actually not essential. Such evidence does not itself establish that conduct is misleading or deceptive, but rather that the question whether conduct is misleading or deceptive is objective, and the court must determine that question for itself. The fourth principle it highlighted is not sufficient if the conduct merely causes confusion, And finally, the fifth principle, where the impugned conduct is directed to the public generally, the court must consider the likely characteristics of the ordinary or reasonable member of the class to whom the conduct is directed, disregarding reactions that might be regarded as extreme or fanciful. So really honing back in on that ordinary and reasonable member test. Next slide, thanks, Mitch. So now this next case we will look at is the case of Cargill Australia Limited and Viterra Malt Proprietary Limited, which was actually heard earlier this year and concerned a business producing malt from Australian barley fields. This case provides an example of where misleading and deceptive conduct can occur in relation to large sales of corporate entities and not just your small consumer protection claims made under the Australian consumer law. So the plaintiff in this case was Cargill Australia, who was a wholly owned subsidiary of Cargill Incorporated, basically a global supplier of food and food products. The defendant in this case was Viterra Malt Proprietary Limited and its ultimate holding company, Glencore International AG. This case was centered around the sale of another business, Joe White Maltings Proprietary Limited, an Australian company that produced malt from barley and was acquired by the defendant in 2009. The next slide, thanks, Mitch. So now I'll go into a bit of the background as to what's happened here in this case. So in December 2012, Glencore purchased the corporate group that included Viterra Limited with all of its subsidiaries, including Joe White, which in 2013, Joe White was actually the largest maltster operating in the Asia Pacific region. Now, following the acquisition, Glencore sold Joe White through a two-phase auction process. Now, in phase one of the sale process, Glencore provided prospective purchasers it had selected with an information memorandum containing financial and operational information about Joe White. In phase two, the prospective purchasers as chosen by Glencore were able to then ask questions and were given access to a data room that contained further commercial, financial, and legal information about Joe White. This further information was provided to allow a due diligence to be conducted before making a final bid. Now, the plaintiff in this case, Cargill, participated in the sale process and conducted a due diligence before making a final bid. However, soon after, Glencore contacted Cargill, and as a result of further discussions in the final bid, the final bid was actually increased by $15 million. Now, Cargill actually purchased the business based on its assessment of the value of the business and its ability to perform. And it was anticipated ownership of the business would result in substantial benefits being reaped, including as part of an existing global operation. So on the 4th of August 2013, Cargill Australia entered into an agreement with Viterra to purchase all of the shares in Joe White, as well as some additional assets which were used by Joe White. So the purchase was completed a few months later on the 31st of October 2013 for a price of $420 million. Now, in this case, there were many issues for determination. However, most of them, as I said, stem from the conduct engaged in relation to the sale of Joe White and in relation to the manner in which Joe White's business produced and sold malt. The claims made by the plaintiff, Cargill, allege that defendants engaged in misleading and deceitful conduct, including failing to disclose material information during the due diligence process about Joe White's prior to the plaintiff entering into the acquisition agreement. So having a look specifically at what Cargill alleged, the defendants made a series of misrepresentations and did not disclose that Joe White routinely and without informing its customers supplied malt that did not comply with customers' contractual requirements and specifications, and supplied certificate of analysis to customers that misstated the results of analytical testing of malt supplied by physically altering the printed results. Now, as a result of the misstatements, the certificate of analysis were issued and reported that malt supplied to customers of Joe White complied with contractual requirements and specifications when it did not. Some of these examples being that different barley varieties were used or failed to be disclosed, which were not approved by customers. Certain elements were used in the malting process, such as certain acids, which had specifically been prohibited by some customers so that customers could market their beer as a natural product. Now, Cargill alleged that had it known of these practices mentioned above, it would have either not entered into the acquisition agreement or it would have terminated the acquisition agreement prior to completion. So ultimately, Cargill sought as compensation the difference between the amount it paid for Joe White, being the $420 million, and the true value of Joe White at the date of completion, which Cargill Australia contended was substantially less. Now, the claims made by the defendants were that they outright denied the claims brought by Cargill, broadly alleging that if Cargill Australia established its claims, it was only because the third parties made misleading representations or failed to disclose material information to the defendants about Joe White's business practices prior to the sale. However, an employee, Mr. Hughes, was not acting or making any representations on their behalf during the selling process, but he was actually employed by the different companies as well. Now, the outcome of this case at a very high level was that Cargill Australia successfully established that Glencore and Viterra made misleading representations. So basically, the defendants' submissions were rejected, and it was established that the memorandum had been prepared by Glencore and its subsidiaries to provide background information to assist in the decision-making process as to whether or not to purchase Joe White. So it was ultimately found that at various stages along the sale process, upon entering into the acquisition agreement, and again before completion of the acquisition agreement, misrepresentations were actually made. It was found that in the absence of those representations, Cargill Australia would not have entered into the acquisition agreement or completed it, and that the conduct giving rise to those representations was fraudulent and that the defendant was liable for deceit. So accordingly, on the various grounds, Cargill Australia was entitled to an award of damages in the amount of being the difference between the purchase price of $420 million and the true value of Joe White's business as at the 31st of October 2013, which to date is still being determined. Now, just on a key few takeaways from this case, I guess, normally in sale agreements, there are limitations or qualification provisions which attempt to limit or reduce the liability and risk between the parties. And sometimes these provisions are key points of negotiations during a sale process. However, something to keep at the forefront of your mind is, whilst there was a limitation provision in this case for the sale of Joe White's business, that provision was deemed ineffective based on the misleading and deceptive conduct, in that had it not been for the misleading and deceptive conduct of not disclosing Joe White's operating practices, the plaintiff Cargill would not have entered into the agreement to purchase the business, or would have terminated at an earlier stage. Another key takeaway from this case was that if a disclaimer contains a statement that tries to exclude liability for misleading and deceptive conduct, and misleading and deceptive conduct occurs, then such a disclaimer will not exclude liability from being apportioned to the contravening party. Importantly, I guess, if you are considering selling your business, then ensure that disclosures are complete, accurate, and not misleading, as there may be circumstances in which disclosure or non-disclosure being silence of certain material information may constitute misleading and deceptive conduct. All right, Mitch, so that's the end of our slides here. So I think Are there any questions?
Thanks, Ash. Yeah, as you can see, everyone, a lot of these cases hinge on some pretty technical analysis by the courts and looking carefully at the conduct that's happened. So tread carefully is the message. We do have time for a couple of questions. None have come through yet, so take that as a good sign that we've hopefully addressed a lot of your queries and concerns throughout the session. So if you do want to look into this anymore or other information that we about litigation and disputes that we are seeing, we do publish articles very regularly on our website there at sherrockpittman.com.au, and also we will post those on our social media when we are regularly as they are being published. So do follow those pages if you'd like to keep up with the latest information that our lawyers are writing about and publishing, and check out the library there on the website too if you would like. We don't have any questions that have come through, so we'll start wrapping up. And I apologise, one has come through. What level of defence is caveat emptor in negotiations and outcomes? That's a good question. Thank you, Mark. Caroline, do you want to take that one?
I think it, and again, this is very general.
Explain what caveat emptor means. Yeah.
I think it's sort of the buyer beware, the caveat emptor, buyer beware. And it really, if you've engaged in misleading, deceptive conduct, the idea behind it is that the buyer would never have been able to find that out. And so buyer beware is not really a defence in these circumstances if your conduct is objectively misleading and deceptive. If it's not objective, misleading, deceptive, and for example, you've given all the information there and the buyer did not look at the information, or the buyer didn't pay any attention to the information or didn't dig into it, well, then your buyer beware is going to be relevant to a defence to that, but not if your conduct is objectively misleading and deceptive. For example, you have withheld something, or you have specifically said something during the process that is contrary to what is in your documents, and they haven't kind of read through the documents because effectively you know that you've said something that is different to what is in your documents and objectively could mislead somebody, even if they'd read the documents, because then they're going to be, well, is what you said correct, or is what I'm reading in the documents correct? I hope that answers the question.
Yeah, I hope that's answered the question. Mark, that was a good one. Thank you. Thanks, Caroline. All right, we'll start wrapping up. So yeah, do check up those resources if you're interested in finding anything more out, or if things pop up in your business from time to time, do check out the website. And finally, a quick plug, if you'll forgive me, if you're interested in looking at driving excellence and high performance in your business or organisation, do take a look at David Sharrock's book, Fighting for Enterprise Success, which is available in hard copy and an ebook. It's chock full of practical ideas about leadership, team building, vision, workplace culture, all those important things, and a lot of material that we provided from our firm as well, just by way of example. So I do commend that to you as well. And before we wrap up, we have had one final question come in, Caroline. Do you have any examples of a typical duration of a case in litigation for a plaintiff who's claiming that someone has misled them in a business transaction? Good question.
Yeah, I mean, you can probably see from the dates in that Cargill case, it took years for the case to be. So they can actually mislead. Your huge misleading deceptive conduct cases can actually take quite a few years to be dealt with, particularly because they will involve a lot of expert evidence on, what is the loss that has arisen from them, evidence from consumers and others and experts about whether something is objectively going to mislead or deceive. You also have to prove a lot of evidence. So your small cases, 1 to 2 years, your big cases can take, 5, 6, 7.
And keep in mind too, George, who asked the question, and anyone else who's wondering, very few cases actually do make it all the way to a final judgment and a trial before a judge, whether it's in this sort of area or other types of litigation. Most disputes are resolved earlier on, so don't be just deterred or discouraged by those long timeframes. If you find that something's going wrong and you want to take some action, it can usually be resolved sooner than that by way of some kind of settlement or negotiation, or just some strong sort of pushing to get the other side to back down and stop what they're doing. So these are some, Caroline's right, these matters do take years, but they are sort of the at the extreme end.
They are, and they're the ones where they're really hard fought out. And I should probably, because what's more relevant to your business and where I'm seeing this come up a lot is in your kind of misleading and deceptive conduct in terms of like intellectual property and holding yourself out as being similar to another company. And those are usually actually, dealt with quite quickly. Once you've kind of brought the conduct to the other side's attention and said to them, hey, we see what you're doing here. You're breaching the law. Stop doing it. Those are usually sorted out quite quickly. It's more, and not to deter you from litigating, it is more the kind of big ones where you're talking about lots of money, where people will go to their corners, and where the conduct is it's a bit questionable as to whether or not it's misleading or deceptive, and where all those little technical legal arguments come into place, like the caveat emptor. Is it something they could have found out for themselves? Was all the information there? Did they make the wrong assumption themselves, and none of my conduct could have given rise to it being misleading or deceptive? And as Mitchell said, most cases will settle beforehand. The courts these days in particular are really looking to push parties to mediations or arbitrations early, to try and settle matters. And so often they do settle beforehand. I was just giving you, I guess, the worst case scenario in those big cases.
All right, no more questions that have come through. Thanks everybody for attending. We appreciate you taking the time out of your busy days. And as I said, do get in touch if you have any questions on anything we've discussed or that comes up in the future, and we'd be very happy to hear from you. Thanks again for joining us. And in the meantime, we wish you a great day, and we'll see you again next time. Thank you.
Thank you.